right. How's everybody doing today on this Thursday or Wednesday? What day is it? Wednesday, I think. Yeah, Wednesday. Anyways, my name is 12 Gauge and welcome to my channel, 12 Gauge Investigative. I wanted to do the second part of Let's Go to Court, the breakdown of the court process that I started the other night. So if you'd like to join me, this is not live, but this is an upload that is going to be alive. So feel free to commentate as you will. And we'll finish this up that I started the other night. You will see two of me in this process. You're going to see me on the left-hand side, which is the live, and me in the little box in the actual upload, and that is the previous me. So let's go ahead and begin.
About who to excuse, because they have the right to.
Yeah, like you were saying, the attorneys question the potential jurors, like where they got their, where they listen to their news from. Is it local? Is it national? Do they have any biases? Will there be, whether they're, anti-government or anything like that? I mean, if they have any kind of preconceived religious biases or anything like that, then they either exclude them, or depending on the case that they're trying and it works in their favor, then they might pick this individual.
Excuse a certain number without giving any reason, as long as they're not acting on the basis of discrimination. They can just say, I don't like school teachers. I think they're bad jurors for this case. So, you're a school teacher, out. So it allows the parties to sort of figure out who's best for this case.
Zia, do you apply any particular strategy to jury selection?
Pick the best jurors. It's challenging. I think that it's. I had the opportunity to argue at an appellate court this exact issue. Struck a juror, and there was a strike made. When we struck, the defense said that it was for reasons of race, and had to provide a race-neutral reason. And when it was in front of the circuit court, I generally like to be fairly familiar, I guess, to tell a little bit of jokes. And so I just told the narrative. I had just gotten engaged to my wife, who is a PhD scientist. And I said that, if this juror was sitting the way that when I'm at the dinner table, my wife starts talking about very technical science materials, slumped over, kind of looking away, I said I would be sleeping on the couch. And I think that, those are things that are not like, you can't put your finger on it. It's a lot of intuition. It's an art, not a science. And you never really know what's going to happen. So I guess that's the closest I get to the position of having that kind of mystery file, or the mystery what's out there. There's a total asymmetry of information. You may have a juror that you think. I recently had a trial, and with the foreperson was a corporate lawyer, and it was a kind of a technical case. We actually had a law enforcement agent we were prosecuting for smuggling money out and not filing those forms you get on the airplanes. And I thought they'll definitely convict because it's so serious. And they convicted on one charge that we thought we wouldn't win, and they convicted on the other one. And we thought this juror was going to be great for the technical charge. And so it just goes to show you, I think that we probably, we're analytic people. And so I think we sometimes overthink. A lot of it is you just got to hope for the best and hope that you're going to get people fair. But I don't know. I think by and large, people are not coming up with wild excuses when they're faced with a federal judge asking the question, are you really someone who believes you can't put someone in prison? Are you really,
And, being on a jury takes a lot of dimensions when the attorneys are trying to get the better jurors for their case, whether it be the defense trying to get somebody that's anti-death penalty, like let's say they haven't had experiences such as what the defendant is being tried for. They don't have any biases towards that. So they're more apt to try to get these types of jurors than somebody who is pro-defense, pro-life in prison, longer terms, things like this. So that's what he's discussing right now.
Most people back down and say, look, I'll be fair and honest. And I think that, they're in a community, they're peers. You can't really have often people who are just kind of outlandish and doing wild things. So you kind of hope for the best.
So Kiana, how do you approach jury selection? And we mentioned that you study unconscious bias before. If you could weave that into your answer, that would be great.
Sure. So I think as a defense attorney, one of the things that we're trained to do is actually have a plan when it comes to selecting a jury. So if you get an opportunity to have what's called attorney conducted voir dire versus judge conducted voir dire, then it has to be consistent with your theme and theory of the case, your theory of innocence for your client. And so most defense attorneys, including myself, we go in with a plan and we have some ideas of the types of jurors that we're looking at. But it's a misnomer to say you're selecting a jury. I think what we're moving toward, at least in my community, is we're deselecting a jury. We're plucking out the people who we don't think can contain their bias, or maybe this just isn't the case for them. You know, some people, there's just certain topics that there's no way, because we are all subject to unconscious bias. All of us in this room, out there, you can't leave that at the courthouse doors as much as you would like to. So as a defense attorney, we're more trying to get people to open up about where their biases lie. And I'll just say this, what the studies show is there's no voodoo to picking a jury. All you can do is sort of prime them to remember you're supposed to be unbiased. And by asking them questions about bias, you prime them to be more careful when it comes to making an ultimate decision. And that's about as good as we can get.
Judge Hudson, tell me a little bit about voir dire in your court.
Well, I have a standard series of questions that are very extensive. It probably takes me a half hour to 45 minutes to go through them with the jury. Before I even begin my voir dire, I always ask the defense attorneys in advance, 7 days in advance, to submit to me their proposed voir dire questions. So I integrate those in. I go through whether they are related in any way to the lawyers, the defendants.
So these individuals are very versed in their job duties, and they carry them out well. There's no sense of biasness in their voices and their application toward doing their jobs. And, you know, it was mentioned about the Constitution as a joke or something. Do people view the Constitution as a joke? I don't want to paraphrase that. Let me see what it says. It says Constitution means nothing. One thing I want to say about that comment is it's interesting to me that if you have a different of opinion towards something, or you're trying to present something to educate individuals, okay? But yet, whenever you have a bias, and that's what they're talking about right now, you don't want those type of people on the jury, because they're going to be more proactive toward their bias rather than being objective. So it's interesting to me, the individuals that are biased in certain cases about proven innocence before guilt is this and that and the other. You know, I understand the court process. I understand that when you're arrested and you're waiting trial, you are presumed innocent until guilty. I get that. But it does not say that everything up until the trial means that you're innocent. It does not mean that the cops got it wrong, the lawyers got it wrong, the investigators got it wrong, the forensic people got it wrong. If your anti-government statements towards people that are trying to present the facts of how things work, and you still don't see how the process works, then you have a bunch of bias, and nobody could ever show you different. So that's why a lot of times in the chats, I don't like to get involved in those conversations, because you can't change another person's mind. You can't. You can't. And that's real talk, 12 gauge. I mean, because, you know, it is essential to be objective in these type of things when it comes to only understanding so much of the case, only understanding so much of the court process, because no matter what individuals can read, there's only a particular point of reference that they can bring to their argument. And unless they're attorney, they are not versed in the understanding of how to present these cases as these individuals are, and breaking it down for us right now. And that's fine. But to be calling names and ridiculing people and things like that It just very, very counterproductive. I mean, I'm not even talking about that case, so I don't even know why you're bringing all this stuff up. Obviously, somebody in the chat during this breakdown of cases was talking about the Idaho 4, so they were referencing calling names or something. So just kind of ignore that and let's move on. Wait, don't. You know, I'm talking about this bank robbery case, and we're listening to these individuals discuss the process. So, whatever case you're talking about, I don't understand, I guess, based on what you're talking about, that. See, I'm not talking about that case. I'm not talking about that case. I'm talking about this bank robbery case that they're talking about in here. That's what we've been talking about the whole time. I'm not talking about the Idaho 4 case. I'm talking about this bank robbery case, and they're breaking down the whole case based on the procedural of the court process and their roles and how they get information, evidence and things like that. That's what I've been talking about the whole time. I haven't been talking about the Idaho 4 case.
Have they ever met lawyers of the defendants? I go through the list of witnesses in the case. I go through the occupation, their occupation, the occupation, members of their family, whether they're members of the NRA, whether they're a member of any organization that is in favor of legalizing drugs and drug cases, whether or not that any of them are police officers, whatever the nature of the case is. I try to find out whether anybody in their family might be in a position to have formed an opinion, and that could be contagious. It could affect them, and whether or not they've studied the law or any member of their family is a lawyer, and whether or not they understand they got to set that aside and base their decision strictly on the law as I provided.
A criminal trial begins with opening statements, first from the prosecutor and then the defense lawyer. So Zia and Kiana, in that order. Zia, tell us what kinds of things you try to focus on when you're doing an opening statement.
I think the thing you're trying to do is you're trying to tell a narrative, a story. You know, there could be a very complicated fraud, Ponzi scheme investigation. It could be a bank robbery like this case, but whatever you're trying to do, you're trying to create a simple narrative because folks haven't seen the video, right, in the jurors yet. And this is, the government is lucky to make the first impression. And so you both want to put out the narrative, what happens. But we always say that, in terms of strategy, you also want to take the sting out of anything that might be bad. So,
and that is true. Like the court case that I witnessed the other day, you get to see what nobody else has seen, and to be able to see this evidence, it opens your mind to a different perspective rather than what you've heard. I mean, because we discussed, I would kind of give in a speed synopsis of the case before I even went over there. So I was thinking one way. Well, when the evidence was presented in the court, it totally blew me away because you got to see the sneakers with the blood on them. You got to see the clothes with the bullet residues on the clothing. You got to see the gun. You got to see the clip. You got to see the photos of the deceased. I mean, you got to see it all. And when you see that stuff, it just totally takes your mind to a different place. And that's what he's talking about right now. It's like you get to see a part of the reality of the crime, not the person, but the criminal act that they're being accused of. So the attorneys are painting a narrative, like he said. They're giving you an outline of the case. That's all they're doing. And then it goes from there.
say, for instance, there's some fact that that's really going to look bad for one of your witnesses, or a fact that that really is in the benefit of the defense. You're going to take the earliest opportunity to get it out there so it looks like that the other side isn't getting that and that you weren't unprepared for it. You want, really, at the end of the day, the jury to think that this is our burden as the government, that we're prepared, we're organized, and that we're being fair and just laying the facts out without adding any color or showmanship and things like that.
Kiana.
Well, our strategy, I think, for opening statement is pretty much what Zia said, is to tell a story. As human beings, we're wired for story. So as defense attorneys, we pride ourselves in being the one that tells the best story, the best trailer for what the jury is about to see. We want them to be interested and watch out for things that we think are weaknesses in the government's case. And also, we may talk about things that we know will come out in the trial, and we never overpromise things that we aren't sure whether it'll come out, and if it does come out, whether it'll come out our way. So opening statements, I think, are important. I think you can have 50 defense attorneys in a room and they try it 50 different ways. So it's not a prescription.
And that's an awesome point there. She is a defense attorney, so she's telling you can try 50 different cases, and there's going to be tried 50 different ways. That there's no one standard or method of operation per each case. So individuals that talk about these cases being prototyped, or they're doing this case like this case, or they're echoing this case, not necessarily.
But it ultimately is about story, keeping the attention and telling them what they're about to see and why the government has it wrong.
So I want
And those of you that follow true crime or have been following true crime for a long time, you do understand the Casey Anthony case. And I bring that case up a lot because, like with that case, they had a lot of evidence. They had photos, they had videos, they had sworn statement, they had, the body, they had, the car in which, the body was moved from location to location. They had blood, they had, all this stuff on Casey Anthony. And I believe that what got her off was the presentation of her lawyer to convince the jury that she was innocent. They were able to buy into the lawyer's narrative and were unwilling to look at the evidence that tied a mother to that murder. Do I know she did it? No. But based on the evidence, it looked like she did it. I don't know any other person that could have done that. But she lied on so many aspects of the journey through the process. I had her dead to right, guilty, and then when I found out, because I didn't follow the case, I saw the documentary and I thought, holy shit, she's not guilty? How did that happen? Well, basically the prosecution didn't bring a strong enough case to convince those jurors of her guilt with the evidence that they had, And that is interesting to me, is how these lawyers have the capability to sway the jury one way or the other, even if you do have the evidence. Like the other day in that trial that I keep bringing up, that capital murder trial that I witnessed, had the assistant DA not got up there and showed the evidence after the defense attorney finished his presentation, I was almost leaning toward not guilty. I promise you not, because the prosecution, he was a Millie Mouse speaking person, and he didn't bring a strong enough emphasis on guilt with the evidence. It wasn't until the assistant DA got up there and she put the emphasis on it. And I believe that that's what turned the jury into the guilty verdict. But it was an interesting sight to see. If you've never been to a trial, I suggest that you go and check one out. They're very, very dramatic. And you see it and you hear a lot of things that you normally wouldn't see. Even on TV, I don't think you get the full impact.
I want to actually turn to our two judges. And from this point on, Judge Orenstein is a magistrate judge, and magistrate judges do not try federal felonies. So we're going to draw now on your experience as a former federal prosecutor. But I'd welcome the thoughts from Judge Orenstein and Judge Hudson. What are the qualities of a strong opening statement?
Well, short to the point, here's what we're going to prove and here's how. And establishing yourself, whether you're the prosecutor or defender, establishing yourself as the person the jurors can look to for the voice of reason. He's the voice of authority in the courtroom, but you're the person who's going to be, giving the honest broker of the facts, so that when things are in doubt, they'll look to your side and think you have some credibility.
I've always believed that opening statement, like final argument, is one of the greatest exercises of applied psychology you will ever have. And what it really is having a commonsensical approach to the evidence. It's the art of persuasion. In both a final argument as well as the opening statement, I think it's important to stress the main points in your case, but also give a commonsensical path of how they're going to reach the conclusion that's favorable to you. And that, I think, is the magic behind being a really effective litigator.
So I want to talk just briefly on the human side of this. Kiana, you have a real life defendant sitting next to you who might be going away for a long time. What are they going through while this is happening?
Yeah, I always have a real life defendant sitting next to me, and I think that's what makes me different. I'm dealing with people whose lives are really in crisis, and they're nervous and anxious oftentimes before trial. I make a point of the night before going to visit my clients because they're not going to sleep that night either. The family pressures are great. It's just riddled with anxiety. And part of my job is not only to be a persuasive and effective litigator, but it's also to counsel my client in a way that makes them feel confident that they're going to be treated with dignity and fairness and effectiveness.
And the human side for both you and Zia, you guys must be going through tremendous stresses for this moment of just having everything together for trial, standing before the jury. Do you go through any jitters or stage fright when this happens?
Go back to, I don't know if it's either very good or very bad to be married to a lawyer but the one thing my wife knows is if there's a trial, it's just kind of, to stay away. It's not a good time. You get stressed out. You're working longer hours. You still have your regular docket, right? So, I can't imagine how many clients that you have. So you have to still go home at the evenings and pay attention to those other cases. And so it is a challenging time. I can't speak for anyone, but I find it hard to believe that most lawyers don't get a little nervous, no matter the most experienced ones, when you're standing up in front of a judge, let alone a jury. A jury is a total, you have an unknown. You don't know what you're getting into. And you're nervous because, it's your profession. You care about it. You want to do the right thing. And I think as a prosecutor, there are some cases where it's more obvious than others that there could be victims or there could be a threat to the community. And you feel like if you mess up that, someone could be hurt by what you hope is not a mistake that you make. So absolutely it is, you get nervous, but by the same token, after you get a few of them under your belt, once you start going, then it's like driving or anything else. I think you start to you just want to get into a rhythm and keep things going. That's why, some people think an effective way to play defense or offense, whatever you're going to call it, is to try to object and things like that. I think it's bad because I think jurors get annoyed because it breaks up their rhythm and judges want things be orderly. But some people think that's an effective way because it can throw the other person off from their rhythm sometimes.
So Judge Hudson, you are in the position of having to manage the trial, starting with the jury, but then all the different motions, objections, and everything. What are the biggest things you have to factor in just running the trial?
Well, I want to keep it moving. I want to make sure that the evidence presented is competent evidence. I'm not going to be reversed on appeal. I want to be sure that I rule on the objections properly that come out. And while I don't always object on my own to things, if a lawyer is doing something that could lead to reversible error, I'm very, very quick to correct them, irrespective of whether or not a motion is made. I want to be sure that the jurors are treated properly and the time is not wasted during the course of the trial. And I want to make sure the jurors are properly instructed, and I want to be sure that all of the defendant's rights are properly attended to during the course of the trial. It's basically what
This judge sounds like a very active judge in his courtroom. The fact that he's active in the whole court process, just not sitting up there listening. He's actively seeing if, any of either side, if there's any kind of situation that later on could appeal the process based on a miscarriage of justice in the courtroom. I like what he's saying because he sounds like a very attentive individual.
what I do in a kind of an overarching fashion.
So I want to come back. We mentioned the judge managing the trial, and earlier came up that lawyers also have to manage a lot of balls. Zia's mentioned a few. Kiana, do you want to talk about just a little bit of what other things you have to manage getting ready for trial?
Yes, I think it's important to say that I'm the defense attorney, but I don't do it alone. There's often, if I'm well-funded and supported, have an investigator, a paralegal, sometimes a social worker, also working with me. And often at the table, I'll have a paralegal with me as well. And so we're managing our team as well as the defendant, because remember, a defendant sometimes, like a bank robbery like this, may have sat through a week and a half of people saying things that he or she does not agree with. They have to bite their tongue. And so I have to prep them for what that feels like to hold their tongue, because they don't get to take the stand until the end. And sometimes just the anxiety of that and not being able to say, they got that wrong, or that's not, so we have to manage our client emotions as well.
So we're going to do one last question in the trial for the two lawyers, and then we'll start wrapping up the section. Zia and Kiana, tell us a little bit about how you organize your case, how you choose which witnesses, how you try to build it through evidence. And of course, Kiana, with your side, how do you decide whether to put your client on the stand or not? So Zia, if you could get us started with that.
Usually what we try to think of is kind of the bookends, as you want to finish and off with a really strong witness, I think, who presents well. And you want to start with a witness who's going to set the table. And the in-between is where you're at risk of losing interest and things like that. And so those two are where I would say I start with is, who am I going to finish with and who am I going to start with? And then kind of work my way in the middle. You have I guess a natural inclination of wanting to do overwhelming shock and awe, put everything in, and that is not, I think, the best way to try a case. But I would say, again, everyone is different. You got to do the case the way that you feel natural and comfortable, because the jurors are looking for one thing. I think that's authenticity. And so if you have 4 witnesses that saw these people come in and you have the video, you do not need to put on 4 witnesses. That's going to annoy the jurors, because they, we already heard that. Okay, move on, because they want to get back to their lives.
That's a strong statement right there. They don't want overkill. They don't want you to be pressing what they've heard already over and over and over.
I think it's going to annoy the judges, because judges feel like it's their job to shepherd an efficient trial. And it's great for the defense lawyer, because 4 people have seen 4 things that are identical, somewhat similar, but also differently. And so you're just putting yourself at real risk when you want to do that. So trying to get just the least amount of witnesses necessary to tell your story.
I think for me, any witness that I'm going to call has to be helpful to our case theory of innocence. And that's sort of the filter that I put every witness through. They have to be credible, believable, and relevant to the questions. Trials are actually, people think they're about a whole bunch of things. They're about the elements of robbery, really. And every witness has to add something to answering the questions about whether the elements of robbery are met. And if they're not, there's no reason for me to call them. Same by cross-examining witnesses of the government. I think it's hard for defense attorneys to learn that some of your best questioning is to know when to be quiet. As far as whether I put my defendant on the stand, I try to tell my clients that I don't work for them, I work with them. And they are as much a part of the team as all the other people that are on their team. And so it's a choice, again, much like whether they plea, whether a person testifies at their trial is their choice. All I can do is prep them. But
Another time that she uses that word choice. So it sounds like this defense attorney really pushes the accountability on the person they're trying to represent. She's not pushing. Like she just said, she works with the client. She doesn't work for the client. So she's giving the client the opportunity to make their own choices. That way they're in charge of how it plays out. Like she chooses, like if the defendant chooses to take the stand, I'm sure she's going to say, well, I'd advise against that. But if that's what you feel that you need to do, I will, I'll let you, but it's always a choice. I like how she's talking as well. I mean, this panel is really well versed in their job.
I think I've learned over time is I tend to put my clients on the stand a little more often than maybe even my supervisor would like me to, because we're human and jurors want to hear my client's side of the story. And so if we can put him on and it's credible and relevant and there's some perspective that he or she can add that isn't there through the government's case, then absolutely I'll put them on.
Please.
I agree with her completely. One of the biggest mistakes that I see in all the, I tried over 100 jury trials, is asking a question, asking one question too many. When a lawyer gets a question that gets an answer to a question that is extremely helpful to their case, shut up and sit down. Because you might on that next question get the response, well, wait a minute, I want to clarify my answer to the last question. And that's particularly true on cross-examination. When you strike gold, sit down.
Good advice for future lawyers. We're going to go all the way down, beginning with Kiana and ending up with Judge Hudson. This is the moment of jury decision, or even everything leading up to jury, waiting for the jury to come back. Kiana, what's happening with you, your clients, pretty much everybody? Just what is this like from the various perspectives you hold? And for you, Judge Hornstein, as a prosecutor, I think.
Yeah, I think waiting for a jury verdict to return is like waiting for a baby to be born. It is anxiety riddled, but you're somewhat excited. If the trial went well, you're pleased with the work that you've done. But I can't ever forget that I represent a person. So it's not really about me and how I feel, but I have to remember to go to lockup. Usually my client, when we're waiting for a verdict, is in a lockup in the courthouse and sometimes right behind the courtroom. And I get to go to my office, and usually I'm walking in circles because I can't eat, I can't do work. So I'll go over and I'll sit with my client and we'll talk about what happened at the trial. I make a point to tell them what a pleasure it was to represent them, no matter what happens in the verdict. And I hear how they're feeling. So that's usually what's going on with me when I'm waiting for a verdict to return.
See ya.
I think there's a similar where a lot of pacing. You can kind of tell in the hallways when you know someone is waiting for a verdict to come back, because people are both avoiding the person but also trying to send positive thoughts to them. I think it's just stressful, and especially the moment we were waiting for the jury to read the verdict. It's an incredibly tense moment, and I think I hope that other people feel like, I was educated when I started in St. Louis by the U.S. Attorney's Office there, is that it's not like that we're high-fiving as prosecutors when it's over. If someone gets a 10-year sentence or 20-year sentence, it's sad. Someone's life is, as Kiana's saying, they are taken away from their family, and that's not a good thing. There are people who are around that person that are going to suffer. And so you have to really, as a prosecutor, be ready to hear someone say not just not guilty, but ready to hear them say guilty, and know that you feel comfortable that the right thing is happening if that happens.
See, I like that he just said that. That was so humane right there. And he's the prosecutor. He said they're not sitting there high-fiving themselves that they took somebody out of society away from their families. But the fact that, if they are guilty, that they feel confident that they made the right decisions. That they did what they could to show that they were guilty. I like what these two are saying right here. And the judges. I mean, this whole panel is pretty darn good.
Yeah, and so as a litigator, I was mostly working as a prosecutor. It is a little different, and perhaps more like Kiana's experience as a prosecutor, when there's a victim in the case, which isn't very often in criminal trials. So then you're helping somebody get through that process a little more. But yeah, it's the most nerve-wracking time that you go through as a lawyer.
Well, for a judge, it's a little bit easier. I'm just sitting back in the office talking to my staff and waiting for a verdict and answering the questions of the jury as best as I possibly can. One of the most important things that we do is to make sure the jury has the support they need, copies of the exhibits, any other items they want to inspect, the guns and things like that. My bailiff handles all that. I just sit back on cruise control and wait until he comes in and tells me there's a verdict.
Although actually something was mentioned during the video, the notion of a potentially hung jury. Have you ever had juries that have struggled to get to a verdict?
I have, and what I do is I'll give them a modified Allen charge, which is kind of a statement to say that if you can't render a verdict in the case, your neighbor's going to have to come back next week and hear the same evidence and make the same decision. Hopefully that'll coax them into a decision.
Basically, I'd just like to ask, we've had a wonderfully full discussion. Thank you so much. I'd like to ask, starting with Kiana and moving towards Judge Hudson, what is one thing you would like people in this audience to take from today's discussion? And something I'm also curious about, we're talking about an adversary process with many rules that guide the introduction of evidence. As you talk about one thing you'd like us to take away, I'd welcome your thoughts on just generally how successful the process is at delivering justice. So, Kiana? start off with you.
I'll start with your last question first. I think it's difficult to measure how successful we are at delivering justice because still in our society, we have a mass incarceration that has disproportionate representation of people of color in the system. And for all of us, that should be a concern. So if there's not an even sort of people who are in the system for various reasons, then I'm not sure we're reaching justice because we have too many, I think, Black and brown people who are incarcerated and maybe not as well funded as they need to be on the defense side. One thing I would say, though, I love my job. I love being a public defender. I consider it an honor. We get to tell people stories. And I think Brian Stevenson says it best that no one person is the sum of things that they did on their worst day. But I get to come in on their worst day and say, I'm with you. I'm aligning with you. I'm going to shoot for fairness, going to negotiate on your behalf and try to get as close to justice as we can.
No, if I ever commit a crime, I know I'm going to. I feel like Kiana, she sold me. She's a public defender, but if she had a business, I mean, she's. I feel that's very moving. I think that the thing to think about is I also I love my job, and I think that I struggle maybe with some of those same issues of thinking about making sure, am I doing my job the right way, and making sure that justice is being evenly doled out. I think the best thing about being a prosecutor is, at least in my experience in both St. Louis and DC, U.S. Attorney's offices, no one is measuring your success by how long of sentences and things you're doing. What they're measuring is, are you doing the right thing and do you feel like you're doing the right thing? And I think there's very few jobs where you can go to where that's what you're being measured on. And that's why I think being a prosecutor, if you are doing the right place and have the right support, it's a really great and important job.
Do we always get to justice? Probably not, but we have a system filled with people who aren't in it for the money, that's for sure. They're doing it because they're trying to get it right, and that gets us a long way there. I'm not sure that you can measure justice by did we get the right result of guilty or not guilty. I think one of the things that we have to aim for is looking for other ways to deal with problems of crime by getting at their root causes. Courts can't really solve that, but they can try by getting away from these ideas of it's just about getting somebody to trial or to jail or declared innocent. We can be partners in trying to solve the problems that create the crime.
I can't look you in the eye and tell you that our criminal justice system is flawless, because it is not. But it is the best that I have seen. Until someone comes up with a better idea, I think we're well served by the system that we have.
I want to thank everybody on the panel. Unfortunately, we're out of time. So I want to thank those of you who asked questions and for joining us in today's knowledge seminar. And then for all of us here at the administrative office, I'm Charlie Hall. We look forward to seeing you at the next knowledge seminar.
All right. So there you have the second part of the court process breakdown. The first part was just as interesting. So if you didn't really get to see the first part, it's in the library. It's probably a couple days back. So why don't you take a look at that and then come back and watch the second part. It is a federal panel. So pretty much the federal and state statutes and protocols, they kind of vary a little bit, but for the most part, they're right on point. If you're in the area tonight, why don't you stop by and see Sonia D and myself at 8 o'clock Central as we join together on panel to talk about Idaho 4 and more. If you're in the vicinity and would like a good conversation, come spend the evening with us, and you just never know who else might hop on panel. I hope that you enjoyed this. And like I always say, Maestro, cue that music.